Good afternoon, everyone, and welcome to our Drye State Attorney General webinar series, where today we will be speaking with the South Carolina Attorney General's office, including Attorney General Alan Wilson, who is with us. I'm going to give it about a minute, and then we will officially get started. I just want to give folks time to be able to join in, and then I'll give a few ground rules, and then we will hear from the general. So just stand by, everyone. Right. Well, I will get us started here. Welcome again to our State Attorney General webinar series today. I'm Paul Singer. I'm a partner and I chair our State Attorney General practice here at Kelley Drye. For those familiar with this series, you will be familiar with my colleagues who are joining me today, Abby Stempson and Beth Chun, who are both special counsel, and Andrea deLorimier, who is a associate, all part of our state attorney general group here at Kelley Drye. And we are really excited to have today's discussion with the South Carolina Attorney General's office, where we're going to get a little bit in the weeds on some fairly recent IRS regulations and how they have impacted consumer protection settlements. Before we get started, I want to give a few ground rules and then I'll introduce our speakers. First, if you have questions throughout the webinar, please feel free to use the Q&A button that you'll see at the bottom of the screen. We will do our best to try to address any questions that come up throughout the hour today. If we don't get to them, however, those familiar with this series know that we follow up the webinar with a blog post that will give details about what's discussed and will address any questions that were outstanding. We'll also have a recording of this webinar available for folks after the fact. For those that are seeking CLE today, I will be reading a 4-digit CLE code at some point during this webinar. I will read it twice. Please make sure to take note of that code. You will need to put it into the CLE form that will be provided via a hyperlink, I think both in the chat and in a follow-up email after the fact. So with that, let's turn to our agenda for today. As I said, I really appreciate the South Carolina Attorney General's office taking the time today. We are joined by Attorney General Alan Wilson, along with Jared Libet, who is a longtime consumer protection lawyer, someone that Abby, Beth, and I all worked with very closely with when we were in our respective AG offices, and now continue to get to work with now that we're on the other side. Just really welcome to both of you, and thank you both for taking the time today to join us. I'm going to just hand it off to General Wilson to give us some opening remarks. I know the General's going to have to drop after he gives us some background on sort of his view of consumer protection and his philosophies in South Carolina. So, General, I will pass it off to you.
Well, first off, thank you so much for having me on the webinar today. It's an honor to be here. First, a couple of basic housekeeping and ground rules for me. If I say anything stupid or offensive, Jared Libet will be on right after me to address those issues and smooth them over. And if you have any difficult questions, please reserve those for Jared Libet when he takes the mic after I drop off. In all seriousness, Jared, I see you on there. Why don't you wave at everyone so they can see you? Okay, I always joke, Jared's my chief cat herder in consumer protection, and I'm his chief cat. But in all seriousness, everyone, it is great to be on the webinar with you today. Let me start by saying this. I've been Attorney General now. I was elected this coming Tuesday will be 15 years since I was elected Attorney General, which means in January I will celebrate my 15th anniversary as being sworn in as South Carolina's 51st Attorney General. I was 37 years old when I was elected, and at the age of 52, I look back on the last 15 years And I kind of joked to myself at 37, I think I still had Similac on my breath. I was still a child, and couldn't believe they let someone that young run the Attorney General's office. But now, having been there 15 years, I've had a chance to not only grow as an attorney and as an elected official, but the office has actually grown and evolved as times have evolved with technology and whatnot. And so I've been there long enough to see a lot of changes. Um, when I first came into the Attorney General's office, I spent the first 6 months to a year trying to figure out, what kind of philosophy I wanted to govern the office with. I thought I knew what I wanted to govern with, but I wanted to make sure that, let me go back a little bit and say this. I realized that when a junior attorney or a paralegal at the AG's office calls someone at a company, even if it's a Fortune 100 company, somehow that phone call makes its way all the way up to the C-suite, because if there is a concern, if we're asking questions, I realize the anxiety and consternation it can create with companies who do business in South Carolina. And so I tell people I'm very meek with my power as Attorney General, and I encourage my staff to be very meek with the power they have. And what I mean by meekness is not weakness. Meekness is power under control, recognizing that we need to do our due diligence. Whenever an allegation is made against someone violating consumer protection laws in South Carolina, the first question I inevitably ask is, who are all the stakeholders, right? I want to know, not, if someone say, who are the people that regulate? Who are the companies involved? We don't want to weigh in on an amicus brief or a complaint or a letter, a comment letter, whatever the case may be. We want to make sure that we have talked to all the relevant stakeholders. If there's a law firm that we know out there around the country that we have a relationship through our association with NAG or AGA or the Republican AG Association, I want to make sure that we talk to that person first. Someone comes in and has made an allegation against Acme, company, Acme Corp. And the first thing I want to know is that, well, John Doe or Jane Doe, I had dinner with them at NAG, 3 months ago. I don't want them to read about us investigating or doing a CID or anything to their client or their company if they're in the C-suite, without me talking to them first. So predictability is the first thing I want to make I tell people I don't guarantee outcomes, I guarantee processes. And I try to make the process in the Attorney General's office here in South Carolina as predictable as I can. Um, so over the years, when someone comes in and alleges a violation of consumer protection laws, we obviously hear that person out. If the person's complaining and they want to seek to bring a consumer protection complaint in South Carolina, I'm certainly open to that, but I'm equally open to reaching out to the person who's been alleged to have violated that and give them a chance. We never, ever make a decision or take an action without inviting the complainee. If we hear from the complainant, we like to hear from the complainee as well. Over the years, I've developed what's called the meritorious and compelling state interest test. After hearing from the complainant or the person alleging the consumer violation, we go meet with the companies or the individuals involved, and we let them present to us. And my team and I have kind of come up with this. It's almost kind of like how a judge would apply a philosophy. First, is it meritorious on its face? Is the allegation, the complaint being alleged, meritorious on its face? And secondly, if it's meritorious, is legal action the most appropriate? Is there a compelling state interest? Is there something that compels the state of South Carolina to get involved? Is there another way to remediate or deal with this issue outside of being engaged in litigation? And if we can't survive that, then we will move through to the next phase, which is obviously reaching out to the company to inform them. You should never read about us, and if you do, it's an oversight on our part, but you should never read about us taking an action against you or anyone without being engaged by you or engaged with you. I tell plaintiffs firms and defense firms alike, including people operating in the private sector, I view our office when it comes to consumer protection very similar or akin to that as a referee on a football field. We're in the middle of football season. Everyone's got a team. I'm a long-suffering Gamecock fan, and we have equally long-suffering Tiger fans in our state. But nonetheless, I'll use the football metaphor. You look at the referee. The referee, we see ourselves as the guy or girl in the black and white striped shirt. We're out there trying to make sure that the rules of the game are played fairly, that we're protecting the players on the field from unfair competitive advantages or for deceptive advantages. Our job is to, when someone violates a rule, is to apply the appropriate remedy or the proper punitive measure. We're not trying to, for instance, in football, someone lowers the crown of their helmet and hits someone, that's targeting. And if it's viewed as intentional, you get kicked out of the game. Well, there are states out there and people out there with a philosophy. They see companies as a big bag of cash, and every play is going to be a targeting. Sometimes it's just an offsides, 5-yard penalty, replay the down, right? Sometimes it's, we pick our yellow laundry up off the field and put it back in our pocket and say, you know what, there was no offense. I've had meetings before where we thought there was something going on after meeting with the complainee, the company that was alleged to have violated our SCUPA laws. We did some due diligence and realized there was no there. Or if there was a there, it wasn't as egregious as originally thought. And so I tell every company that does business in South Carolina, you are a corporate citizen of this state, which means you are a citizen of this state. You may not be a voter in the state, but you are a citizen nonetheless from my point of view. And I want to treat you as fairly as I would want any citizen in this state treated. So when I sit down with Jared Libet, who you'll hear from shortly, when I sit down with Sonny Jones and other members of our consumer protection team, we always try to play with an open hand. We don't hide our cards. We try to give you as much predictability as we possibly can, and we give predictability to everybody. And so I've tried to govern the office that way for the last decade and a half. And for the next year and 3 months that I'm Attorney General, I intend to do it until my very last day in office. Hopefully, I'll be in another office in January of 27. But until then, I will be the Attorney General and I will continue to govern this way. I want to thank all of you for allowing me the opportunity to do an introduction. I know Jared's going to go into some more meaty stuff, but I just wanted to kind of give all of you who are listening today an overview of my philosophy on the application of consumer protection laws in our state and how we work with other states. With that being said, are there any questions for me, or do y'all want to just skip to the fun stuff? I was the warm-up act.
General, I do have a question for you. I thought your remarks really resonated because one of the things that, we deal with a lot in consulting with our clients is this balance of a client may be a little bit uneasy with approaching your office proactively and wanting to engage because they don't necessarily want to put themselves on the
Mhm.
radar. But you said a few things that I think are important to note, which really we've heard from other attorneys general as well, that the importance of sort of being a known player and a known corporate citizen operating in the state. It can only help you down the road to make sure that when you have an issue or something arises, you've already got that relationship. You already are sort of a known good actor in the
Yes.
state and someone that you can engage with. I didn't know if there's anything you can kind of add to
Yeah,
that sentiment because that's obviously something we try to advise folks on as
you
well.
you teed it up beautifully because I probably should have gone into this, but since you teed it up, you've allowed me an opportunity to circle back and insert something. Relationships are important. I had a senior member of the bar, an elder statesman in our state government who practiced law for many years, once tell me the three most important prongs to professional success are what you know, who you know, and who knows you. You can be the smartest guy in the room, the best lawyer, the best advocate, the best lobbyist, whatever. But if no one knows who you are or you don't know who anyone is, you're almost useless. It doesn't matter how smart you are. So you have to have equal measure in all three areas. If people know who you are and you have a good reputation, you can open doors at different levels of organizations and you can open them faster. That ability to pick up the phone and call an AG. Many people that attend AGA, NAG, and RAGA have my cell phone, and their ability to pick up the phone and call me and set up a meeting within a day or two is very important to their clients. And also, if I know them and trust them, we don't have to sit at the negotiation table or the conference room table and build trust. Or I mean, we can kind of just go straight to the heart of what's going on. We can cut to the chase, get the bottom line up front, and that's always helpful. So I think relationships are so important. What's also kind of funny, having been a long tenured attorney general, I have seen an evolution. I remember years ago, RAGA, and I think we're starting to do it again, but we started and then we discontinued, and I think we're going to pick it up, is a general counsel summit. So if you think about it, most of the, and y'all tell me if you think I'm wrong, but it's been my general understanding that on average, people who go to these, you know, RAGA, DAGA, RSLC, NAG, AGA, NGA, RGA, DGA, the RCCC, all these elected groups and partisan groups and nonpartisan election groups, are usually government affairs people. And especially in the AG space. In the AG space, it's especially pronounced where you have government affairs people showing up. And I've noticed the first year that we had a general counsel summit, we were inviting GCs from some of the largest companies in America and around the world. And a number of them showed up. And it was almost like an eighth grade school dance. All of the AGs and our staffs were sitting we were wallflowers on one side of the wall, and the general counsels were on the other side of the wall. And it was almost like a fear to get out there on the dance floor and start dancing, like in the eighth grade. And that's kind of a funny analogy, but that's what it felt like. And then after one or two AGs started talking, and then one or two GCs started talking, people felt comfortable. And what I had learned is whenever an attorney general would call the proverbial C-suite of a company or a headquarters and say, hey, there's been an allegation that y'all have violated some law. The first thing as I have observed, is you've got the government affairs guy is saying, what's the first thing they say? Let's go sit down and talk to the AG. Let's go sit down and have dinner with them, or have a meeting with them. And then you go across the hall into the general counsel section, which is across the hall from the government affairs section. You got the general counsel saying, everyone shut your damn mouths. Everyone don't do anything. Let us, and it's almost like two different, and sometimes it's right for a GC to say, don't talk. Let's, the lawyer's job is to slow your roll. Sometimes the government affairs person's job is to speed it up, to get to the conversation quickly. And what I learned from the general counsel summits is when the GCs got to know the AGs personally, at least, and I can't speak for every AG, because maybe not every AG in the Republican or Democratic side thinks the way I do. I think most on my side of the aisle do. I'll let our friends on the other side of the aisle speak for themselves. But once I develop a relationship with someone, the last thing I want to do is burn it. Now, again, I may have to call a friend up and say, hey, there's been a credible allegation made about your company or about your client. We need to talk about it. And, I will be as fair and as predictable as I can be. But that doesn't mean I won't not go forward. It just means that the person on the other side needs to have a comfort level with me, that they can trust me, that I'm not out to shake you down. And once I've developed that relationship, I find that the meetings go very well. So I would encourage you, those of you who are on this webinar, if you're already in the AG space, develop relationships with the AGs that you deal with. Develop relationships with their staffs. I will tell you right now, Sonny Jones and Jared Libet are two attorneys that I think they understand they know where my heart is. They know where my head is. They know what my appetite is for consumer protection. They know that I'm loath to go after companies strictly to shake them down. They know that I don't like that. So they are very thoughtful about that. And when they talk to me, I listen intently. So if you're talking to them, know this: your ability to engage them and convince them of your position is really important, because you might be able to call me directly, but I'm always going to circle back and hear what they have to say. Doesn't mean I always agree, or doesn't mean I always do what they say, but I am heavily influenced by what they say because of our years and years of working together. So developing relationships with the senior people in your consumer protection divisions of the respective AG's office, I cannot underscore that enough. Developing relationships with the AGs is important, but developing relationships with their deputies and their assistant deputies is equally important. And those relationships are important. So I cannot underscore, it's not just enough to be the smartest lawyer in the room. You got to know people, and they got to know who you are.
Well, General, thank you for that. That you actually hit on what was going to be my other question about coordinating and working with staff directly, because I mean, I know from my time in the Texas AG's office, it was the same dynamic, right? If someone goes to the AG and tries to complain that staff is being unreasonable or on not working with them on an issue, you're always going to go talk to staff, and you're always going to value and listen to their input. And it really is, at the end of the day, just building trust and mutual respect among all of us, the business community, outside counsel, the AG, consumer staff. Everyone has to have that mutual respect and trust with each other, and that's how you get things done, is once you've accomplished that. So yes, thank you so much for these remarks today.
Well, thank you for giving me the platform and the opportunity. And again, y'all are going to enjoy Jared. He can take a very dry subject and make it saucy. So I wish I could stay on, but I really do have another meeting to pop off to. But thank you again for facilitating this, and I hope to see you again real soon, all of you.
Yep. Thank you, General.
Thanks,
Thank you.
General.
All right, Jared. Well, no pressure, but now you need to make it saucy. So we're going to move into our consumer protection lightning round. For those that have participated in our webinars before, you know that we like to ask a core set of base, simple questions to each AG office. This is really useful to really understand sort of how consumer protection operates in the state, but also some of the differences from state to state that we see. So I'm going to kick us off with our first set of questions here. So Jared, a really tough one. I think the general may have already, spoiled this for you, but how is the AG selected in South Carolina?
Yeah, it's a popular election, 4-year terms, no term limits for AG. And like the general said, he's going to be concluding his 4th and final term as Attorney General here in the next year, and wish him the best in his run for governor.
Absolutely. Correct me if I'm wrong, but is he not currently the longest serving Attorney General that's currently in office?
That's correct, and
Yes.
that's
I'm
quite an
surprised
accomplishment.
he didn't mention that because I've heard him mention that on multiple occasions. But yes, I think by like a couple days he holds it. But yes, that's right. So can you tell us, Jared, how consumer protection is organized in your office?
Sure. So, we're a smaller office, which means that we've got one division that handles consumer protection, antitrust, and also charities. So all of those things fall kind of within our purview. All the attorneys in my section have their hands in all 3 of those buckets and work on cases in those spaces.
So given the breadth of what you guys cover, how do you determine priorities for your consumer protection enforcement?
Yeah, so it's again, being in a small office, we've got really constant access to the chief deputy, to the attorney general, and it's kind of both top down and bottom up at the same time. So, the general or our chief deputy will often um, talk to someone who's got an issue or flag something that they'd like us to kind of take a look at to see if there's anything that we need to focus our attention on. But also he's very open and will listen to the folks in our section. If we hear about a case, whether it's from some of our sister states who are working on a case, or even just something that we see in the media that looks like, hey, this could be an issue, something that we'd like to take a look at. And some of our bigger cases have kind of started that way too. So we really have the flexibility to either work on something that comes across the general's desk that he'd like to take a look at, or he'll usually give us some leeway to go and check out things for ourselves. Obviously, we're keeping him in the loop and reporting on everything we're doing and everything we're finding. But having that flexibility and freedom is nice.
And do you work with other states in multi-state investigations?
Just once or twice, yeah. No,
Once or twice,
all the
yes.
time. Again, smaller office, so multi-states are a big way for us to kind of share resources. We wouldn't have them here to handle all of the cases we'd like to be involved in just ourselves. So those partnerships with other states are really invaluable to us in ensuring that we're able to focus on any priorities the general has without sort of requiring each of us to work 120 hours a week. So.
And let's take the next two questions together. Do you receive consumer complaints and then what do you do with them? Do you perform any sort of complaint resolution function?
Yeah, South Carolina is pretty unusual in that we really don't receive a lot of direct consumer complaints. We have a separate Department of Consumer Affairs that is not within the AG's office, and they really take on that role. So, to the extent we do get consumer complaints that come here just from folks who aren't aware of where they need to go, we'll usually direct them to Consumer Affairs, and there's a good relationship there. We'll share information with them, they'll share information with us. They have a separate section of the code that they typically enforce, but we have a good relationship with them.
Great. Well, I'm going to hand it off, I think, to Andrea next to
Yep.
continue the questions.
So what is your primary consumer protection statute?
So that would be the South Carolina Unfair Trade Practices Act, and that's code section 39-5-10, and going on from there.
Are you able to conduct pre-suit investigations by statute?
Yes, we've got statutory authority to do those before filing a lawsuit.
And can you request documents?
Yeah, we can, and typically that's our most common way of getting information before we consider whether or not to file a lawsuit, is requesting documents from a target.
And can you take statements or send interrogatories?
Yes to both. Statements that we would take are testifying under oath. So sort of practically, it looks like a deposition, even though it's not called a deposition. But we would have, a court reporter there to transcribe it, and they would swear a witness in. And then kind of same with interrogatories. Our statute's pretty broad. It allows us to request both sort of documents as well as information.
And are CIDs that you send confidential, and are the answers confidential?
So the CIDs that we send are not confidential. We don't have a protection for those. We don't certainly publish them, but if we were to get an open records request, we would need to turn over the CIDs that we send out. The answers are confidential, at least with regard to public records laws. The statutory provision at issue allows us to share those answers only for law enforcement purposes in the public interest, which we interpret to be if we need to file a complaint, that would be a law enforcement purpose. If we're working with other states in a multi-state, that would be a law enforcement purpose. But obviously we don't publicize them. And if we were to get an open records request for answers to a CID, we would take the position those are not available to be turned over.
And can a party object or set aside a CID? And if so, in what time frame?
Yes, they can petition our trial court here to either limit or set aside a CID. The time frame is either the date in the CID they have to respond or 20 days, whichever is shorter. So typically, we usually put 30 days in our CIDs, which will extend as a matter of courtesy. So usually the 20 days is the notice that people need to be aware of if they do want to set it aside. But certainly, like the general said, we're happy to talk. So if we were to issue a CID that you had concerns with or wanted to talk with us on, we'd hope that folks would approach us to have those conversations and see if we can work something out before running off to a court.
And how can you enforce compliance with the CID?
So kind of the same way we would petition our court here to enforce the terms of our CID, and the statute allows us to do that.
And do you have a statute of limitations?
We do. So it's a 3-year statute of limitations. South Carolina uses the discovery rule. So it's not when the action occurs, it's when we knew or reasonably should have known that the actions took place. South Carolina's Supreme Court has also adopted a continuing violation doctrine, which means that even if we did know of conduct, say 5 years ago, and decided not to take any action, we're always able to come in and address the last 3 years that it was going on. So if it's been going on for 5 years, we may not be able to go back fully to the beginning of it, but we can certainly take action, one, injunctive, relief to go forward and stop conduct that we want stopped. But in terms of any sort of, monetary piece or penalties, we'd be able to go back 3 years.
And then lastly, do you have to provide pre-suit notice? And if so, in what time frame?
Yeah, so I think we're also rare in that we do have a statutory requirement of pre-suit notice. It's a 3-day notice, but it also provides in the statute for an opportunity for the company or individual to be heard. And we take that obligation seriously, so that if we were to send this notice and someone needs to come in and meet but can't meet for a couple of weeks, 9 times out of 10, that's going to be just fine. We'll accommodate those schedules. There is an exception in the statute if the general determines that the purposes of the article will be substantially impaired, then we can move forward without issuing the notice. And that would be something like if we needed to seek a TRO we can obviously make a decision that the notice would not be helpful to that process and move forward without it.
Great. I will turn it to Beth then.
Thank you. Okay, so after the investigation, what types of settlements can you enter into?
So I would say that the three biggest categories are just run-of-the-mill settlement agreements. We also do AVCs, assurance of voluntary compliance, and consent judgments.
And what's your penalty authority?
Yeah, so the statute provides civil penalties of up to $5,000 per violation. And we use a willfulness standard, which is defined as knew or should have known in order to trigger the penalties.
And can you obtain restitution and disgorgement? And does the willfulness factor in there too?
Yeah, so we don't need the willfulness standard to get any other relief. We can obtain restitution. It's sort of called ascertainable loss in South Carolina, but it's the same concept. We don't have an explicit ability to obtain disgorgement. Our interpretation of the statute, though, is because the language is broad. It specifically talks about the court's ability to enter into whatever orders are necessary to sort of redress the harms caused. Our interpretation would be that we could seek disgorgement, and certainly until somebody told us otherwise.
And when you're making decisions on what to seek in these settlements, are there times that you don't seek injunctive relief or times that you don't seek penalties or a payment?
So I can't think of a single circumstance where we've not sought injunctive relief. Usually that's our primary driver. And we really sort of focus on that because the biggest goal is to make sure if there is bad conduct that it stops, figure out what might need to change so that it is unlikely to happen again. I can't also think of a case where we have not at least put a request in for some sort of monetary penalties, at least at the front end, but I know that we've settled cases on injunctive terms only. So it might be part of the case to start with simply because we're putting out there anything we might reasonably get. But in terms of resolution, not every case is a money case. We recognize that. Not every case is a restitution case. And we're happy to sort of make that be the outcome if it's the right outcome.
And given the importance of the injunctive relief you were just talking about, how are you able to actually enforce those terms? And does it depend on the form of the settlement agreement, like an AVC, like you were talking about?
Yeah, so our AVCs are filed with the court here. That's part of the statute. So whether in those, well, I guess it's a little bit different. So if we have an actual consent judgment, something that a court has blessed, then if the injunctive terms in that document are violated, we have heightened penalties of up to $15,000 per violation that we can go after in those circumstances. For AVCs, it's a little bit different. What the language in the statute says is that it's then a violation of the injunctive terms is prima facie a violation of the statute. So even if otherwise it might not necessarily be an unfair trade practice, that's how it's interpreted here. So we'd be able to go and seek relief if an AVC term was violated like it had been an unfair trade practice.
Okay, and now going to some specific other consumer protection statutes. Do you have specific laws or remedies for price gouging?
We do. It's code section 39.5.145, so it lives within our Unfair Trade Practices Act. It provides, I think, sort of similar provisions to what other states have. It's a declaration of emergency by either the president or the governor or the attorney general can declare sort of a disruption of the market. One thing that's unusual, at least compared to the rest of our consumer protection authority, is that price gouging is also a misdemeanor. And I know that our criminal side of the office has looked at cases involving price gouging issues in the past because, I think us, like every state, will get kind of weather events. We've been fortunate this year with hurricanes, but we know it's not the case every year. And we all take those provisions very seriously.
Yeah, and interestingly, not every state actually does require a disaster declaration or its official declaration from the governor, which does make things somewhat tricky sometimes for certain states. So do you have specific laws and remedies for auto renewals?
We do not have anything specific for that. I think we would just say it kind of falls under our general UDAP authority.
And what about a comprehensive privacy law or any other privacy laws we should know about that you can think of?
Yeah, we do not have sort of a general privacy law. We do have a breach notification law. I think it's 39-1-90 that just provides for, obviously, if there's personal information that gets leaked out there into the public sphere, there's requisite notifications that have to get made. Those actually go to our Department of Consumer Affairs, even though we commonly get them too. We know a lot of states it's required to go to the AG, and sometimes it's just easier to send it out on blast to all 56 of us than it is to kind of look through and see where it goes particularly. So, but we're always in close contact with our Department of Consumer Affairs about those privacy issues because we are involved in some of those data privacy multi-states as well.
And any other new or noteworthy consumer protection laws that we should know about that are recently introduced or passed?
Yeah, so I think the only one that's come out recently is we have a Child Online Safety Act. And that is a statute that requires age verification for websites that have a substantial amount of adult content. It provides for a private right of action if either it's showing inappropriate content to minors without age verification, or if it takes in information and does not dispose of it after it does its age verification. It also gives the Attorney General the ability to enforce for injunctive relief there as well.
Thanks. And with that, I think you and Abby are going to be discussing the main topic for today. So thank you.
Sure.
So Jared, we're going to spend the next 22 minutes with you enlightening the world on some IRS regulations that frankly, a few years ago, we were talking about a lot. I think you and I gave multiple presentations on this topic. And so now I want to hear from you on how these rules have gone. So let's start out with your disclaimer.
Yep. Not speaking for anyone other than myself. I'm not a tax lawyer. I'm not your lawyer, and I'm definitely not your tax lawyer. So.
And he says all this, but I will tell you, I feel like in the AG community, he may be the most knowledgeable human in regard to these IRS regs. So tell us about it. Give us some history here, Jared. What's going on?
Yeah, and I'll say the other part of the history, Abby, is that it's also your fault back when you were at NAG, because I had read some blast email or something about these changes that were coming, thought, hey, this is going to impact our consumer protection cases, asked you if you'd heard of it, and you said, nope, but why don't you look it up and tell me more about it? And that turned into many years and many fun panels. So thank you for that.
Lots of phone calls to you, I'm sure.
Yeah.
Yeah.
So this is, I don't know if I could call it recent history at this point, but for anyone who's interested, so the old way that we used to take payments under our settlements and treat them for tax purposes is that anything was okay to be deducted unless it was a civil penalty. But the tables really kind of flipped on their heads with Tax Cuts and Jobs Act, and now it's nothing is a tax deduction unless it falls under some exceptions that we're going to talk about. But your starting point is that none of it is a deduction. You can go on to the next slide. And so, yeah, so the purpose is really just to kind of change the landscape and make sure that not everything, I think, in long time ago was being allowed as a deduction. Now it's really sort of limited. And in terms of the exceptions, so there's a few sort of words that I'm gonna lay out here, then we'll kind of talk a little bit more in detail about. So the first is that there's this establishment requirement. The onus is on the taxpayer to establish that the money is either restitution, remediation, and that's designed to fix any damage or harm that was caused by violations of the law, or paid to come into compliance with any law which was violated. The other key requirement is that the money be identified in either a court order or settlement agreement as one of these categories. And the regulations, if you look at them, it says explicitly that meeting the establishment requirement does not meet the identification requirement, and vice versa. So there are two independent requirements that anyone seeking to get a tax deduction for money that they're paying as part of a consumer protection settlement needs to make sure that they've checked both boxes. And of course, because everything's drafted by lawyers, we've got exceptions to exceptions, which means that any amount paid as reimbursement to us or any other government entity for costs is not going to be money you're able to get a tax deduction on. And so I've got both the statutory language and the language from the regulation. You can see even if you put it in the agreement and identify them that way, if it's reimbursement for investigation costs or litigation costs, there's no deduction. And at least my fairest reading of the language is that it would include, costs would include attorney's fees. And that's generally sort of how that would fall under there. So when does it apply? Obviously, I'm from the state AG's office, so it certainly applies in cases I'm involved in, but it applies to a whole lot of other things as well. And so that's governments of, the US government, DC, all the territories, even foreign governments, not just AG's offices, any other sort of state regulators, subdivisions, any sort of agencies that work with our subdivisions or with the federal government. And then you've got some other things that you might not have occurred to you about corporations that are serving as instrumentalities of the government or even non-governmental entities which have some self-regulatory powers, such as enforcing rules and imposing sanctions, as long as those are federal or state. So, we're talking about, I think, just the context that I'm most familiar with in state AG land, but just for your awareness that these rules apply in any sort of interaction you're likely to have with any governmental authority. And the same way, it's not just consumer protection or antitrust. So lots of other areas that my office works in, securities, Medicaid fraud, even on criminal cases, these same kind of rules apply. So your default settings should be that I'm going to need to be aware of and thinking about these rules in any interaction I have with the government involving the payment of money. And if it doesn't apply due to an exception, then that's going to be a rare case. So a few other things to be aware of. It applies, the same rules of the road govern regardless whether there's a lawsuit, regardless of whether there's any sort of admissions of wrongdoing, and regardless of where the money kind of ends up going. And so a lot of our cases in the consumer protection space, sometimes money is paid to parties other than the states. Potentially, we've got a restitution fund administrator. Potentially, we've got an independent monitor who's going to be working with the company to ensure compliance. Those kinds of things are considered and thought of and still sort of fall under the same rules of the road. We'll talk a little bit more about restitution in a moment, but just to note here that unclaimed restitution funds are always kind of an issue because you can't find every single consumer, or some people just don't open envelopes or cash checks that they get. And there was a concern raised when the regulations were coming out about what happens if we're labeling this money as restitution for tax deduction, but it turns out maybe only 80% of it ends up getting claimed or even less. And the regulations say that after efforts have been made, if the money is then deposited in the state's general fund, that's okay. It's not going to impact the tax treatment, but if the money is returned to the company that paid it, it's treated as income. So something to be aware of.
So Jared, maybe you're going to get to this when we get back to restitution, but if that third-party administrator is hired and the money goes directly to them instead of straight to consumers, how does that come into play?
And yeah, so that it's still considered restitution. So
Okay.
it would be a statutory exception, and you could claim a tax deduction for that payment. Yep. So a couple of cases where it isn't, these rules don't apply. So one case is where the government is not acting as an enforcement agent. It's acting as sort of it's enforcing the same rights that any sort of private party would have, like a breach of contract action. That kind of case, that kind of settlement's not going to trigger these same kinds of tax rules. It also doesn't apply, and I was trying to think of a good example, and I don't really have one, but maybe there's cases in other contexts where you have a private settlement or a private judgment in a class action or something that requires some payment to the government. But the government is not a party to the case. In those circumstances, these rules don't apply. And then the last one, I think, is an important one to flag. It also does not apply if it's a routine investigation or audit, if it's conducted to ensure compliance rather in response to suspected wrongdoing. Again, that's not me. If you're getting a call from me, it's probably because of suspected wrongdoing rather than just a routine investigation. But I know a lot of folks probably have those kinds of investigations or audits that they're a part of. And again, as long as the purpose of it is to make sure there's compliance with the law, then if any money gets paid as a consequence of that, it's not going to be subject to these same rules. All right, so really quickly, restitution is what people think it is. It's just how do we get people back to where they were in the absence of whatever harms or damages were caused. You can go to the next one. And one thing that was added in the regulations is that restitution can include amounts paid as disgorgement, as long as one, it's not in excess of the net profits earned by the company. And also the disgorgement can't just go to a state's general fund. If it does, then it's not really restitution anymore. That kind of defeats the whole purpose, basically, of having it be considered restitution if it becomes the state's money to do with it whatever it chooses to. Remediation is really in the environmental context. The language from the regulation, which I've quoted there, is a strong nexus between the purpose of the payment and the environmental harm caused. I looked to see if there was any, relevant case law interpreting sort of what that means, and I haven't found any. I don't think any courts have really considered it yet. But if you're involved with an environmental case, there's a lot of other things and ways that money can be paid as part of a settlement or a judgment to help the environment that would be considered a tax deduction. And it can be paid either directly to the government or to some special account that's set up for purposes of environmental cleanup.
So let's talk about cost of compliance now, because I remember back in the day, we were kind of thinking that that could have been something where a lot of folks determined that a payment was a cost of compliance. So talk to us about this, Jared.
Yeah, and I'll say too, I think even my thinking on this topic has refined a little bit over the last several years. So you'll start with what the regulation says, which is that it's money paid or incurred to come into compliance with the law that the taxpayers violated or alleged to have violated by performing services, taking action, providing property, or any sort of combination thereof. And typically in the kinds of cases I work on, we're really going to be looking at certain kinds of injunctive relief in the settlement and whether or not those would be appropriate compliance costs. But the paid or incurred language is appropriate because I interpret that to mean it can take the form of both either direct payments that are being made to our offices or even just expenditures the company is spending other places in order to bring themselves into compliance with the law. It does not have to be money that's paid to our offices as part of a settlement. We'll see in a moment that you still have to identify and establish it, but it does not have to actually flow into the states in order to be credited. So, and really, the biggest thing I want to highlight here, and again, this comes from the regulations itself, is there has to be a connection between the expense and the law that's alleged to be violated. So you're measuring not, am I spending money to comply with a settlement agreement? That's not the test. The test is, am I spending this money to comply with the law? So I've tried to give some examples. Reasonable minds might differ on some of this. It's sort of the best that I could come up with. So the things that I think are definitely valid compliance costs are if you've been engaged in advertising that the states have said is deceptive and you need to spend some money to go and correct those misstatements, I think that's a compliance cost. If you've put a product out there that's defective or harmful and that needs to be replaced, that's a compliance cost. You know, in the opioids context, one of the big keys for us in looking at the distributors was sort of shipments of massive quantities of pills out to pharmacies without any sort of, you know, red flag program or know your customer program. That's the kind of thing that standing that program up would be a valid compliance cost. However, on sort of the flip side, if you're creating a document repository or you're training some employees or you're giving up money because you're no longer selling a product pursuant to a settlement, these are not compliance costs because, you know, there's not an unfair trade practice claim for failing to set up a document repository or for failing to train your employees just without any sort of other information. So doing those things may be required by the settlement. They may be injunctive terms that are necessary to comply with the language, but the money that is being spent on those, I would not consider those cost of compliance because they're not bringing you into compliance with any laws. And then you've got maybe more of a gray area. Things like standing up more compliance within a business if they don't have sort of a compliance department or a whistleblower hotline or something like that, or they're having to do sort of reports for the states. I know a lot of our settlements will get reports from companies over a number of months or years. Those are maybe a little squishier, but in thinking about them, at least personally, I think those are sort of more appropriately treated as costs to comply with the settlement. Not preparing compliance reports for the states is not in and of itself an unfair trade practice. You know, depending on the circumstances of the situation, things might be a little different, and there's certainly no bright line rules here. I'm just sort of trying to give my best reading on the situation. But going back to sort of the top, I think in asking yourself, is this likely to be a valid compliance cost? I think the question has to be, am I doing this to comply with the law, or am I just doing it to comply with the settlement agreement? And if the answer is the latter, I don't think it's a cost of compliance the IRS is going to accept.
Jared, this sounds like, has this been a point of contention in past negotiations?
You know, interestingly, not really. I would say in the settlements that I have been involved with, and now several of them since the new rules of the road here, either I have not heard anything about the tax provisions, and I've had to sort of be the one to sort of flag it for them. Hey, you're going to get this form next year. Just want you to be aware of it. Or the request has been for, we just want some very broad language that says all the money we're paying you is restitution, remediation, or cost of compliance. And there are some cases where that's totally fine because all the money is restitution. But there's been plenty of cases, I say that, and I have a bullet on this later. I can't think of a single case where at least we didn't have some costs. And, you know, limited budgets in state government, we're always looking to recoup any costs we have out of settlement funds, which means unless it was a free case for us to assert it, and I don't think there's been one, we're never going to be able to agree that every dollar you give us is restitution, remediation, or cost of compliance. It might be 99% of the money, but I'm not aware of a case where it's able to be 100%. But in most cases, there's always a lot of detail. And I think to the extent we've had pushback or negotiations on it, it's always sort of come down to how much can we label as restitution. I've really yet to hear meaningfully from a settlement negotiation about, we really want to explore what are compliance costs here for these injunctive terms, and which of these, you know, state AGs you would agree are ones that would fit the definition of compliance with the law. so that we can claim those tax deductions. And I don't know sort of what the impact is on the revenue side from the business. Again, since it's not a tax lawyer. But I would think it'd be more helpful than not to at least have that available as deductions to be claimed. And I think there's sort of a missing opportunity in a lot of our cases to really explore that.
Jared, I know we're running a little short on time, so you tell me how quickly you want to go through these.
Let's go quickly, although I don't have a hard stop at 3, so I'm happy to keep going a few minutes over.
Okay.
So I'll just kind of fly through the next few slides here very quickly, and then we can sort of end on, I've got a couple of practical consideration slides that I think would be a good way for us to sort of end. But, and I think, Abby, these slides are going to be available to folks
Yes.
to look at later. Perfect. So then I really don't need to spend a lot of time talking about it. So if you want to skip ahead to slide 27.
And while you do that, Jared, I'm going to interrupt just for a second because I know we may have some listeners that need to drop right at the hour. And so I'm going to go ahead and give the CLE code for those that are on. Right now, you should see in the chat a link to be able to submit your CLE form. On that form, it will ask for this 4-digit code, and the code is 3292. Once again, the code is 3292. Thank you. And Jared, sorry to interrupt.
No problem. I think you missed an opportunity to make the code 1098, but that's okay. So I just wanted to show this for those who have not seen it, because this is the actual form. One thing we hadn't really talked about, but there's some slides on this, is that as state AGs and governmental entities, we've got an obligation to report to the IRS what our settlements look like and where sort of the money is broken down. So this is a form that we have to provide to the IRS. We also have to give the same information to the taxpayer. And so everyone, at least by seeing it here, can be familiar with it. It's very short. This is the entire form. It's just got some basic information about who the taxpayer is, some basic information about the case, and then the money gets essentially divided into 4 boxes, although the boxes don't really have to add up to be the same as each other or to be a total. But that's where sort of everything is going to be flagged. So number 1, total amount of the settlement that's being paid. Number 2 would be a space for civil penalties. Number 3, restitution, remediation, and 4 is compliance costs. But while the form makes it look like boxes 2, 3, and 4 need to add up to box 1, that's actually not the case. So if you've got these internal compliance costs, things that you're spending, but you're not giving money to the states, that's okay. That can still go in box 4. And the IRS would be aware of it. But as the state, we're the one that has to report it. So we need to be on the same page about what we're reporting. And, there don't want to be any sort of confusion, or if there's going to be a fight there, let's have that fight in the context of when we're formulating the settlement, as opposed to 6 months later when we've moved on to other things. So I always want to be upfront with folks about what information is going to be on the form, so there's no surprises.
So Jared, quick question in this regard. Have you, or just any of your colleagues, have you heard of them getting questions from the IRS based on the form submitted?
So, yes, actually, we've gotten a couple of reach outs from the IRS. I obviously can't talk about sort of specifics. But I can say that part of the request was for us to share with them some of our paperwork from the case, which we're happy to do. So I'm not obviously aware, and not going to be aware unless somebody tells me if there's like an audit or a challenge or something. But I can say at least a couple of times in the last couple of years, we fielded questions from the IRS about some of our settlements. So something to be aware of.
Yeah.
All right, so the next few slides are things I think folks can read on their own about the reporting requirements. They really, again, don't even apply to you guys, more than just it's good information to be aware of. If you want to go to slide 30, I will at least just say, because we do talk about multi-states a lot, One of the nice things is that in a multi-state, we can construct it in such a way that one state is doing the form for everybody, which is a really nice way to do it. But sometimes it's not possible. It requires there be basically a common settlement agreement. If you're litigating with 10 different states and 10 different states end up having to do their own sort of resolutions, even if you're doing them all at the same time, you may find yourself in a circumstance where you're getting 10 forms, or particularly if you've got states that maybe aren't always in agreement with each other, which has happened over how the money is going to be used, whether for restitution or just submitting it to our general funds. You may not be able to have a situation where everyone's aligned on one form. And I want to flag that for cost of compliance as well, right? Because if you're working on global peace with a number of states, and as part of that, you're implementing a program and you've done all the hard work of getting all of the different states on board with the same program, you're not going to be able to claim credit for that program, 15 different times and 15 different settlements. You're going to have to figure out, how am I going to attribute this across all of these different states? And maybe it's probably just easiest to see if one state will let you claim full credit for it in their settlement. But just something to be aware of if you're engaged in that sort of complicated multi-state dynamic and not able to just address it all in one place. All right, so just to these last two slides were just a few points that I think will be a good way for us to wrap up the discussion. One thing I'm always looking to do is ensuring settlement language is consistent with what I have to do with the reporting obligations. So I mentioned the costs. I can never agree that all of the money fits in these categories. If our intention is to reclaim costs, if we have outside counsel, the expectation is obviously we're going to pay them attorney's fees. Those are not areas we can claim a restitution or mediation or compliance. But, beyond that, we're of course willing to work with folks on what the right answer is, but it helps to not have to fight over claiming everything, because there's really just not the usual case where that can happen. There are some ways that we address and can address situations where we don't know exactly at the time of settlement how much money is going to be paid. Maybe it's contingent. Maybe even the company doesn't know yet. We want to stand up this program to comply with the law. We're not sure what it's going to cost. There's a way to deal with that on the identification side. There's a code in the form, and those fields can be left blank, and that's fine. But at least for purposes of getting your deduction, at some point, you're going to have these establishment requirement. You're going to have to show the actual payments were made for approved purposes. The last point here is just, the states, I think, generally speaking, speaking for myself anyways, we try to work with everyone on the fairest outcome. But if you're going to have sort of vague or unreasonable terms about compliance costs, those aren't going to be terms we're likely to engage with you on. And just again, remember that key principle from earlier is that you're looking for a link, and we're looking for a link because we've got to be the ones to write it on a form and be happy with it under penalty of perjury. That there's a link between the expenditures you're asking for credit on and the laws that you're alleged to have violated, and you're providing that nexus.
So Jared, the states turn in a form. The business obviously will claim a deduction likely on a tax return. Is the business filing anything else?
No, not unless I think the IRS asks for it. So that establishment requirement, there's a few slides back, that's got sort of a list of documents that the IRS puts in regulations as documents that we might be looking for to sort of meet this establishment requirement. Interestingly, they say the form is not one of them, and the form cannot be used for the establishment requirement. But they're going to be looking for things like pleadings, civil investigative demands, correspondence with the states. So I guess my advice would be, to the extent I'm giving advice, which I'm not, have a file of that kind of thing so that the IRS asks, hey, we'd like to look at some of these costs. You've got the language ready to say, yes, these costs went with this injunctive term, which we contend put us in compliance with the law, sort of whatever the fact pattern is. But it's all spelled out both here and in the regulation in terms of what kinds of information I think are going to be helpful to keep. And then I've got one more slide just to flag a few things. 1098-F forms, if we get a FOIA request for them, and I don't think we've gotten one here. But if we did, we'd, I think, redact the taxpayer identification number, but everything else is probably fair game. If someone asked, like our settlement agreements usually are. You know, Abby and Paul and Beth, these guys would be relevant to you, is that the companies that are paying you for defending against one of our investigations, those are not considered to be amounts paid or incurred to a governmental entity, and so it's beyond the scope of anything we've dealt with here today. Interest falls in line with whatever the interest is on. If it's interest on restitution, you're good. If it's interest on civil penalties, then no deduction there. And just sort of the last thing is that, you know, I think we do a good job in my office of filing the forms that we need to do. I think other states, AG's offices do a pretty good job. I don't pretend to presume that every governmental entity in the country, particularly sort of the smaller offices, are doing it perfectly and always filing the forms they have to file. But the tax law is the tax law. And so you don't get to claim the deduction on money that you paid because a state didn't do its job and file the form. So the form is there to help the IRS, but it's not a get out of jail free card if we don't do it.
Well, Jared, thank you so much. I think especially for our listeners that are practitioners, very important information to have. So appreciate your time. I'm going to turn it back over to Paul to wrap us up.
Yeah, I'll just echo that and thank you, Jared, and again extend thanks to General Wilson. And yeah, I mean it is funny. I mean, this is a topic we've been talking about for a number of years, and yet I think there's still a lot of misunderstanding and just lack of knowledge in the space that it's going to continue to develop over time. But always appreciate you in particular, Jared, and continuing to message this out to the public more generally so that they understand the implications of these changes to the tax code. So thank you a lot for your time today. So, you know, just again, I'll wrap things up and thank everybody. Just a reminder that we do have a monthly newsletter, AG Chronicles, where we highlight a lot of the current trending topics among the AG community that you can subscribe to on our website. And then also on our website, you can access via our link tree. If you hit the next slide, Abby, it'll pop up the QR code. And so that you can access our link tree there. From there, you will get directed to all sorts of general ad law, privacy developments, you know, FTC latest actions, all sorts of information that we provide. And so with that, we will close things out, and just a big thank you to our speakers and to our attendees today. So thanks, everybody.